thanks to Tiago with a very comprehensive and productive introduction about the proceeding of enforcing foreign judgments in Portugal. And after all, I found many similarities between the procedures in Portugal and in China, and especially Dr. Yu has already introduced many things about this, and I will give a more a better framework on this proceeding, and with the in the part with similarities, we will just skip it, and I will try to focus on something special in China. Okay. Well, first, let's just see some general ideas, and the most general idea, or the first thing I would like to introduce, is that there are two phases of enforcing a foreign judgment in China, just like in Portugal, I understand. The first step, you need to get your judgment recognized, and then it can be enforced. While in practice, most conflict or the difficulty just starts from the recognition proceeding, not enforcement. Because if your judgment has been recognized, it can be enforced just like a judgment in China. So the most part, or the most time we will spend here in recognition. And let's see some trends in China about enforcing foreign judgment. While the civil procedure law in China was promulgated in 1922, so it has been 40 years from the start of the civil procedure law, but the provision about enforcing foreign judgment has remained unchanged for 40 years. So what happened, just like Dr. Yu introduced, since 2015 and 2022, what happened? The most, how to say, astonishing part, or the sparking light, is the conference summary published by the Supreme People's Court after a national symposium on trying foreign-related cases in 2022. And after that, they published a conference summary to guide judges all across China about how should you recognize and enforce a foreign judgment. And in this conference summary, there are more detailed guidelines available now. You can see many provisions in detail introducing that how should you review and determine such cases. And in such conference summary, a much more positive attitude has been adopted now compared with the attitude in 40 years before. So let's just get deeper into some general ideas. What judgment can be enforced? I think there are 4 points we can summarize and introduce in very brief and short ways. First, civil and commercial judgments can be enforced, but the name of the judgment is not important. It can be judgment, it can be decision, it can be ruling, but it must be an instrument from court or other judicial authorities. That is the key point. Civil or commercial judgment, and name is not important, but from judicial authority. Second, criminal judgments can be enforced for those that involving civil damages. I think that is quite interesting because in China, some criminal judgments will involve civil damages. And if we have such counterparts from foreign courts, and they come to China to enforce such kind of criminal judgments with civil damages, you can try that. It may be enforced by Chinese courts. The third point is that there is something vague or need to be further discussed. That in specific ways, we have bankruptcy cases, intellectual property cases, cases related to unfair competition and monopoly. Such kind of cases, actually, we speaking in frank ways, they are in doubt for whether it can be recognized and enforced, because in the conference summary we just mentioned, it actually say in a very, very clear way that these kind of cases are with strong features of policies. So we need to get more cautious on such kind of cases. So these kind of cases, they are in a blank. They are in blank. We need to wait and see more more judgments from China, more precedents to observe the attitudes of Chinese courts. And the last one, those documents related to interim measures or other procedural matters cannot be recognized or enforced in China. That is the red line we need to memorize, I understand. So for some specific requirements, I will try to summarize such requirements into different points and in very brief ways. First, just like Diego mentioned, the judgment needs to be final and effective, not appealable anymore, to be recognized. That is very similar with proceeding in Portugal. And second, as Dr. Yu just mentioned, you need to have a treaty with the court of origin and China, or you need to establish the relationship of reciprocity between China and the court of origin. And so here, since we have no treaty with Portugal, how can we determine that we have reciprocity with Portugal so as to enforce a Portuguese judgment? Here are some steps or standards to establish reciprocity. 40 years before, or in the or just as we mentioned, before the conference summary was promulgated this year, China actually adopted a de facto standard to ascertain reciprocity, which means that there must be precedents of enforcing Chinese judgments in the country of court of origin. Then the judgment from this country can be enforced in China. That is the old standard. But now, after the conference summary was promulgated, there are several tests you can try to find. So the first one is that according to the laws of the court of origin, Chinese court, the judgments of Chinese courts can be recognized and enforced in this country. If we find this way, then Chinese courts will find that, okay, so that since our judgments can be enforced, can be recognized in your country according to your laws, so your judgments can be recognized and enforced here. And this year, I think in March this year, Chinese courts, the Shanghai Maritime Court, just recognized judgment from UK according to English law. That is the breakthrough by adopting or applying the conference summary and reviewing foreign laws as the basis to recognize foreign judgments. And the second test is that if you find there is a reciprocal understanding or consensus between judicial authorities of China and the foreign country, then the judgment of this country can be recognized in China. And I understand there is only one example here, is that Singapore. China and Singapore has a memorandum in this way. And in addition to this example, I think I understand no other countries have such kind of reciprocal understanding with China. So this test now is very limited, but still, maybe there will be more countries establishing such kind of understanding or consensus with China. And the last test, the test C, is that if there is a reciprocal commitment between Foreign Affairs Department of China and a foreign country, and no exception of let's say no precedents of refusing to recognize a judgment from foreign country can be found if you have meet such two sub-requirements. Then you can find that, okay, reciprocity between China and this foreign country can be established. But as far as now, I understand no such kind of commitment can be found between China and the foreign country. So maybe in the future you can try this way, but now it is not considerable. So such several tests A, B, and C, as far as I understand, the first test, foreign laws, getting deep into foreign laws and finding they are friendly to Chinese judgments is the most feasible way for our foreign principals or clients to get their judgments being recognized and enforced in China. Okay, and I think in the bottom of this slide, we have mentioned 2 points, reviewed case by case and internal reporting to the SPC. What do they mean? Well, the first, reviewed case by case, means that Chinese courts, they will review the reciprocity case by case. If you have precedent of a reciprocity founded by Chinese courts, you can submit such precedent as evidence, but you cannot get assured that Chinese courts will still do it in the same way because everything changes. So it's the Chinese courts reviewed such kind of cases in the principle of case by case. And the second, internal reporting to the SPC means that most such kind of cases will be heard by intermediate courts in China. We say that is the second level court of China, but they do not have the final say. They have to report such kind of cases level by level until the Supreme People's Court of China to make a decision. So I think that is the purpose of such kind of system is to make sure that everything goes in the same way and we have the same criteria or standard of reviewing cases of recognizing foreign judgments. So the Supreme People's Court, they have the final say. So don't worry about my cases will be tried by a local courts in a way of with bias or in way of unprofessionalism. No, please don't worry about that. The Supreme People's Court, they have the final say. And here are 7 causes of non-recognition. It's just like 7 sins, maybe, if we compare these causes. And I think most causes have already been introduced by Tiago, and many things are very, very similar. So we just go through that in a very quick way. The first is about jurisdiction. If the court rendering the judgment has no jurisdiction over the case, so Chinese court will refuse to recognize its judgment. And the second is about due process, that if the foreign court fail to guarantee the respondent's rights of being notified and heard, or like Diego said, the proceeding is unfair. You do not guarantee my procedural rights, so the judgment cannot be recognized. And the third one is that judgment is obtained by fraud. It's a somehow vague and broad definition or description of this cause, and we need to observe that later. And the fourth one is that there is a conflicting judgment rendered or recognized by PRC courts, by Chinese courts. And the fifth one, public interest. And I understand Tiago just mentioned a very different and interesting point compared with Chinese practice, that in Portugal, there is a public opinion office, right, that will issue some opinions on whether the judgment violates public interest in Portugal. But in China, I understand there's no such kind of system. the burden of applying or claiming that there is a violation on public interest lies on the respondent, lies always the defendant or something. Yeah, it's the right and obligation of the party rather than a third party judicial authority or administrative authority or some other organizations. No, it's all the obligation of the party. And the sixth is that arbitration agreement. The case should not be heard by courts. Yeah, very clear. And the last one is that if the court, the judgment to be recognized has punitive damages exceeding actual losses, the parts exceeding actual losses will be denied by Chinese courts. So I think Chinese law here just intervene into the proceeding of recognition of foreign judgments. This is a question of Chinese law, and here Chinese law just have some review on the merits of the judgment. That is something special. Here let's see some latest practice, but sorry, we have no precedent with Portugal, so no precedents can be observed as of now. But based on the points we just mentioned, especially something new in 2022, I understand an icebreaker from China can be expected. So you can just try to chase a positive result in China here and do not hesitate to try. And here we need Chinese lawyers need help, strong help from Portuguese lawyers, because as we just mentioned, the first step is to establish reciprocity. And such step strongly relies on the understanding of Portuguese law. Even the Portuguese law here is of the essence. So in China, if you need to recognize and enforce a foreign judgment, a strong help and cooperation with foreign lawyers is very, very important. So we also expect a stronger cooperation and communication with all of our foreign counterparts. Okay, so Tiago, maybe in the future we need to communicate more on this. And the last part, enforcement, we just go through this very quickly because in the following webinars, I understand there will be more specific introduction in this part. And the enforcement is somehow a way of compelling the losing party to perform. And this is the power and duty of the court only. Chinese court, they have the power, authority, and duty to enforce a judgment. But for the parties themselves, you have no right to enforce a judgment privately. Sorry, you do not have such right. You need to rely on the court. As for the methods, just similar to Tiago's introduction, there are ways of first tracking down and freezing the property of the losing party, like seizure or some other ways. And the second method is to auction the property that has already been frozen, or like Tiago said, a liquidation. You sell the property being seized and return the money owed to the creditor, and then send the other parts to the debtor back. But if no party, and if no amount is remained, all part will go to the creditor, like liquidation. Yeah, that is the same. But the way of liquidation is to auction the property, and then we do the liquidation. And the third method and the fourth method is somehow, I think, very compelling, very powerful. That is, Chinese courts, they can restrict the consumption or other action of the losing party if they do not perform the judgment for example, they can restrict you from traveling by air, by high-speed trains, and you cannot live in hotels with star levels. Such kind of consumption will be banned by courts. And for some very severe actions, they may trigger criminal punishment. So the third one and the fourth one, I think, is something very powerful and compelling. And the last point is that how can Chinese courts they achieve such kind of methods? How can they complete and make them being realized? So here, the great help from the online system of enforcement. I think that is the most noticeable feature of Chinese courts. They do almost everything through internet, through the system. Chinese courts, they have a system connecting to the say air company and to other authorities of China, say real estate registration, to the company registration, to tax authorities, to almost all authorities. And if they want to do something, they will just click their mouse, and send the information and their request to the authorities they need to communicate. Everything is done. So in China, the enforcement procedure is really, really powerful due to the help of online system. That is something I would like to go through. So due to our limitation on time, we can only go through all things very quickly. But if you have any questions or you have anything you want to get deeper into Chinese system, judicial system, we can go through that in the following webinar, or you can just send emails to me, and I'm very happy to answer all questions from any aspect. Okay.